Okay, so today we have a very interesting talk by Jay Garrison, who I'll introduce a bit in a moment. He's a local attorney up here in the Seattle area. And we're going to be talking about administrative processing. For those who don't know what that is, I'm not sure why you're here, no, but administrative processing is, of course, when your consular case gets thrown into the administrative hellhole of security checks when an issue of security or background concern has come up. We just had a terrible example of this in a case at our firm where a Moroccan client got put into administrative processing for a year. Why? We have absolutely no idea, because they won't tell you what's going on in administrative processing cases. So the common wisdom in one of these cases is that once you get stuck into administrative processing, there is nothing that you can do as an attorney. And I think Jay is here to tell us, at least in part, that that intuition is wrong, and you don't have to totally give up on your role as advocate once your case is dinged for administrative processing. What strategies might you pursue? I have absolutely no idea, and that's why we're going to hear from Jay today. My name's Greg McLaughlin. I'm the managing attorney at Sound Immigration. We're a web-based immigration law firm doing family-based work primarily, serving clients locally here in the US and worldwide. We work primarily through web-based solutions with clients and do little work in person. Most of our work is remotely on the internets. We host two monthly webinars. One is on an issue relating to technology and innovation in the practice of law, and the other is a immigration substantive law CLE. They are all completely free to anybody who cares to join. You can find upcoming events at soundimmigration.com/events. And supposedly you can also register to get notifications of upcoming events, although I hear from Jay that the submission button may be malfunctioning right now, so I will look at that later today. If you are one of the Twitter people, bless you, Jay. If you are a person who tweets, you are welcome to jump into the conversation during the presentation, either using the chat function here on the left-hand side of the webinar, or if you want to hop into the Twittersphere, we're actually live on Periscope right now at web immigration. And the hashtag for following the conversation there will be #SoundTalk. With that very inarticulate introduction, I will load up Jay's slide here and hand the microphone over to him. Jay has indicated that he's more than happy to take questions as he goes along. Jay says that that's the best way to trigger battle stories from him, and he has quite a lot. Jay focuses most of his work on client base from Islamic populations here in Washington State and elsewhere. And the vast majority of his work involves, Jay, is it fair to say, squirrely background issues of various sorts and complex security issues?
That would be accurate.
Okay. I'll hand it over to Jay. Jay, perhaps you could start by just giving a little bit broader picture of your what your work looks like, just so folks have a picture of where you're coming from.
Good day, everybody. So most of my work involves either a fraud or a national security issue. My clients are literally from all over the world, but there is a strong concentration in East Africa, the Middle East, and South Asia. My clients, they're either accused of being terrorists, potentially accused of being terrorists, have an articulable link with terrorism, or have simply done or said something stupid historically that needs correction now. Among the many dumb things that get said or done is refugees have a tendency to not tell UNHCR and USCIS every possible nickname they've ever had. And USCIS these days takes exception to that, and DOS, as a result, also takes exception to it, typically when trying to process cases for their derivatives or their petition for family members in years or decades after the person originally came to the United States and naturalized. So today I'm going to be actually focusing and talking on what administrative processing is, how you can avoid it, and how to get out of it. And can people hear me or not?
Can I jump in with the first question, Jay?
Yep.
Okay, so Alyssa asks, how would you even know if your client has been placed into administrative processing?
Well, the easiest way to know is that case has been sitting around at the consulate for over 60 days, and they tell you it's in administrative processing. But knowing a case is in administrative processing is relatively useless, because starting in, I'm not going to remember the exact year, but I think it was 2006, 2008, DOS stopped telling us what type of administrative processing was holding the case up. And the result of that is that you're going to have to do a lot of detective work about your client, their history, and their immigration history in order to figure out what is actually going on. And so part of the presentation today is to actually go through and help define what actually is administrative processing, how it can be avoided, and then how to get out of it. And I'm just going to repeat this right now. The best thing you can do from the beginning is everything you can to avoid ever getting into administrative processing in the first place. I might have to unmute myself over here. Well, I have to unmute myself on the computer too. Can people hear me? I'm going to keep talking on this one until Greg figures out what happens to the other mic. If there's an echo or anything, let me know. I can always change over to a headset. And it's echoing.
Turn down your audio.
It's off. Here, let's see how many headsets I can have on at the same time. Sounds fine. Can hear now. All right, is the echo gone? Can everyone hear me just fine? Great. All right, so I don't know exactly where we dropped out, so I'm just going to restart here a little bit back. So I'm going to talk about what is administrative processing, how it can be avoided, and I'm just going to start here. If you can avoid it or at least reduce the amount of time it takes, that's going to be far better for you from the beginning. And then I'm going to talk about how to get out of it if you have managed to get there. All right. So what is administrative processing? Administrative processing is a catch-all term for all post-interview processing before a final visa decision has been made at the post. Basically, any case that is otherwise approvable on its face but has an open, unresolved issue is referred to as being administrative processing. A lot of the times it feels kind of like the government's using the wrong tools to solve the problem, but it's also because we've used the wrong tools to solve the problem that it ends up being there in the first place. Unresolved issues in these cases include security advisory opinions, legal advisory opinions, general advisory opinions, fraud checks, supervisory review, waiting for additional evidence from the applicant, although they're not supposed to flag that as administrative processing, they often do. Literal processing of the visa and other issues. Administrative processing is at its most frustrating, though, when it's gone on for several months. Typically, this is caused by a consular post waiting for response on some form of advisory opinion, typically either a legal advisory opinion or a security advisory opinion. You also see it sometimes when there are ongoing fraud checks. Those are actually harder to figure out unless you know a lot about your client. Also, as we experienced back in 2014 and 15, processing delays can result simply from system failures of the consular consolidated database. It's speculated based on subsequent criminal litigation that both of those outages were caused by individuals who had worked at and hacked those databases, and over 500 million pieces of personally identifiable information were compromised. More recently, we're seeing additional administrative hurdles caused by things like the recent flurry of executive orders regarding visa issuance. The most common and seemingly inexplicable causes of delay are fraud detection, legal advisory opinions, and security advisory opinions. I'm hoping most people here understand handling fraud at least a little bit with their clients, and you will end up using the same techniques for that, but I'm not going to go into that in depth because dealing with fraud and remedying fraudulent issues is time consuming and really a topic into itself. Legal advisory opinions are usually anticipated by the attorneys, and many posts will actually inform the client or the attorney when one has been requested. For attorneys, the legal advisory opinion is the area where we are often the most comfortable. We identify the legal question, analyze the law, apply the client's facts, and provide a brief to the consulate about what's going on. Legal advisory opinions are also the area where we usually feel comfortable telling our clients, hey, be patient, it's going to take a while for a Department of State attorney to look at this and verify everything. As a result, I'm not going to spend a lot of time on them unless someone has some very specific questions about dealing with those. Yes. Can questions about the petitioner cause administrative processing? Absolutely. The quick and dirty example that is Adam Walsh Act cases. But in my personal experience, I have a case that actually came to me last year, and what had happened is the individuals, the petitioner and the applicant, were both originally from China. The applicant's now living in Malaysia, but that's kind of beside the point. The petitioner was ultimately visited at home by FDNS because the Department of State, FDNS is Fraud Detection and National Security. It's part of USCIS, and the Fraud Prevention Unit, FPU, is part of DOS. They do work together a lot. So basically what happened is they came, they checked out the individual's house, and found out that my client's ex-husband was still living with her. That's a little bit embarrassing, and it took a lot of figuring out why he was still living there. We actually had substantial proof that it was temporary. He primarily came over to visit the kids. We ultimately did win the case, but it dragged the case on forever. Similarly, in employment cases, this can come up. I've had multiple businesses that had gone for L1 visas and H visas where FDNS will show up after DOS has held the case for over a year to ask, hey, is this a real business? So it does happen. In contrast, security advisory, skip myself a slide ahead. In contrast, security advisory opinions are a black hole of knowledge and a menagerie of terms. Furthermore, reports about the programs designed to protect national security are intentionally vague when reported to the public in order to protect the integrity of the visa system. For us to understand these programs, we have to infer information from applicable laws and regulations, rarely leaked cables, the Foreign Affairs Manual and Handbook, congressional reports, Office of Inspector General reports, privacy impact assessments, and other sources that rarely give us complete and direct information. And if we're lucky, we either have former experience with the Department of State ourselves or know people who do that are willing to talk off the record. Not that I've ever had that happen. I'm aware of 10 different security advisory opinion programs, but a reading of 9FAM 304.2's index actually hints that there's probably 12 SAO programs. SAO is the acronym for this. I'm going to go ahead and skim through all of these, as I believe it's important that you recognize them if you want to figure out the most likely reason that your client's case has been held, which is absolutely necessary if you want to try and fix the case.
Why don't we just repeat this question? Question is whether you've ever had FBI open an investigation on one of your cases for national security reasons. I hope you did.
So, Anne has asked, have I ever had the FBI or anybody notify me whether or not there's an FBI investigation for national security reasons? It is fairly normal for me to have the FBI in my office speaking to petitioners and relatives of immigrant applicants at least monthly, and quite often, depending on the time of year, weekly. Yikes is a correct response there. I actually find it very useful. It's a sharing of information ultimately, because the questions they ask my client tell me what's going on with my client's case and lets me give the client a realistic perspective on how to handle their issues. I could talk about dealing with the FBI for a day. You know, that's a whole separate seminar at the end. And I actually am working on a CLE moment to talk about dealing with the FBI in immigration matters. As well as when the FBI just comes and knocks on your door and says, hey, I want to talk to you, and you don't know why. So I'm going to start back to security advisory opinions. They're literally a menagerie. They're all named after animals, both mythical and real. And I'm going to go through and give you an idea of how to figure out what diplomatic program or what security advisory program your client might be under. So I'm going to start with the diplomatic programs. Most of us aren't going to get those regularly. Visa's horse is actually issued immediately. So I'm going to just break this back down. The various visas programs are the names for the security advisory opinion programs. And they come in three categories. They are reporting programs, where the government is literally just reporting information into the consular consolidated base and one of the many databases it touches. They are programs that are actually executed post-issuance to make sure it is noted internally that this visa has been issued for someone with a special visa. Oftentimes it helps people get through Customs and Border Protection that would otherwise have issues due to their nationality or past experiences. And then there's what generally get called name checks, but in broader are a variety of different types of background checks handled either by the ICE subunit, Homeland Security Investigations, Fraud Prevention Unit, which is posted at several different embassies internationally. So Visa's horse itself is issued immediately after an A, C3, or G visa is issued. A is the diplomatic or foreign government visa. C3 is the foreign government office official transit visa, and G is international organization or NATO. Allegedly, Visa's horse is limited to some specific nationalities. I have never actually seen a list of what those nationalities may be, so I always assume it's probably a general program. There's rarely a hold put on because of it.
Are you going to answer later the question of how we figure out which of these programs we might be in?
So what I'm going to talk about is actually what the programs are, because when you know what the programs are, it gives you a better idea of how to actually deduce which program applies to your client. The reality is you don't always know which one it is, but the tools for dealing with all of them after the case is already stuck are relatively the same. And the tools for dealing with them before depend on you basically putting on your consular officer hat and thinking like a consular officer and saying, which program is my client going to fall into? Plus, the definitions of these programs should give you a pretty good idea of who's going to fall into it. So like the Visa's horse, you're representing a government official or someone from NATO. You know that if their case is held up and they've been told it's approved, but the visa hasn't actually been handed to them, then it might have got some type of Visa's horse emergency hit, although usually it doesn't preclude the visa from actually being handed over. Visa's Pegasus is a name check program. It is for officials of Commonwealth of Independent States. Those are Armenia, Azerbaijan, Belarus, Kazakhstan, Kyrgyzstan, Moldova, Russia, Tajikistan, and Uzbekistan. It potentially includes Turkmenistan, Ukraine, and Georgia. The Visa Pegasus program can result in a hold on an individual. A hold is basically what we tend to refer to as prolonged administrative processing. That hold can be waived for basically high-ranking diplomatic individuals who are entering the U.S. purely to attend a pre-ministerial, ministerial, pre-summit, summit, or White House meeting. So it's typically things dealing with the United Nations. Visa's VIPRE so I will get more into how to find out specifically on which SAO has been requested, but it is far easier to explain which one's requested if you actually know what the various programs are. So, yes, some of those people are Russians. Visa's VIPRE is issued immediately after actually any foreign government official representative to an international organization or their family is issued a visa. Basically, it touches on all the databases that guarantee they will not be harassed when they go through Customs and Border Protection. There is no hold for it, and it is always done post-issuance of the visa, but it must be done immediately. Visa's Eagle is a name check for nationals of Cuba, China, Iran, Vietnam, and Russia. Feel free to guess why those are in a list together. Communism, maybe? I don't know. Also, the countries that the U.S. seems to be historically worried about. It's primarily for people from those countries who are seeking to immigrate to the U.S., so K non-immigrant visas, any immigrant visa, or refugee status. It is a pre-issuance check. That means that it must clear before they will issue the visa. It's done to make sure that there's a biographic data match with the original application, as well as to make sure the various government databases don't get hit showing that this individual has a problem. Requests for that program are directly forwarded to the MVC, who handles the relationship to the Department of Homeland Security. It's always good to know and understand that anything that's an immigrant visa is going to be processed through the MVC or the Kentucky Consular Center, although most of the time through the MVC. And anything that's a non-immigrant visa is handled through visa operations and the Kentucky Consular Center. Let me just finish on Visa's Eagle, and then we can take the question. So after about 10 days, all cases for Visa Eagles should be processed, even if there is no response. That's actually the advisory on a lot of these programs. However, DHS or DOS and even DOJ can request a hold on it that will hold up the case, potentially indefinitely. Yes.
Yeah, I was just wondering what the cutoff there was.
Yeah. Visa's HAWK is the NSIC 3 name check. Basically, it's checking for U.S. criminal history. It also crosses over with some international databases thanks to Interpol and other intelligence agencies. It is required for all immigrant visa applicants and their derivatives. Sometimes it's actually used for non-immigrant visas, although there is a separate program for that. I don't exactly know what that separate program's name is. It checks names, aliases, and dates of birth for individuals not otherwise in the class system, the consular lookout and support system, which is interconnected with the CCD, which is the Consular Consolidated Database. All of this gets to be massive acronym soup after a while. The key thing on this one to always keep in mind is that if you have a child under 16 who's unmarried, they shouldn't be experiencing prolonged holds related to a security issue unless there's a suspicion that their date of birth is incorrect or that the familial relationship is in question or somehow their petitioner has committed fraud elsewhere that would disqualify the child. So unmarried applicants under 16 are not supposed to be held due to the results of this check without evidence of other substantial fraud issues that are usually not holding up the individual, but are holding up other parts of the case. Visa's Mantas is a special check for individuals who have access to specialized technology while in the U.S. or are knowledgeable or learning in a sensitive or critical field. These are the targeted technologies lists. This primarily impacts our F&J students from Cuba, China, Iran, and Russia. But I have actually seen this apply to people from other countries, sometimes because they visited one of those 4 countries, and sometimes because their area of work is highly specialized and may ultimately be concerned. For example, I have a former client who is Kenyan, who's in the United States, has Somali parents, although he wasn't Somali himself, and he is a very specialized energy researcher, and the government put his case on hold under Visa Mantas. The way I found out it was Visa Mantas was after the fact, partially after the fact, because once he was actually granted, he entered the United States, and the FBI and a couple other agencies descended on my office, wanted to ask him questions, and all of their questions were about the type of research done. Homeland Security Investigations, who's heavily connected with the fraud prevention units at the embassies, did threaten in that case to effectively cancel his visa if he did not cooperate. It's always up to you and a gamble for you and up to the client ultimately whether you're going to cooperate and try to call their bluff or find out it's not a bluff.
What technologies are on that list?
I can pull it up real quick. Give me 1/2 seconds. It's in my. It's the technology alert list. And so the technology alert list is basically sensitive goods and technologies. You typically see these for any type of conventional munitions, nuclear technology, physics and engineering, rocket systems and unmanned air vehicles, navigation, avionics, flight control, chemical, biotech, and biomedical engineering, remote sensing, imaging, reconnaissance, advanced computer, microelectronic technology, materials tech, information security, laser and directed energy systems tech, sensors and sensor technology, marine tech, and robotics urban planning. I seriously don't understand why robotics urban planning's on that list. Most of the rest of them are, sensitive government affairs. When I say that something is pre-issuance, it means that the check is done before the visa is issued, but sometimes the individual can otherwise clear ahead of time. It's slightly different from pre-clearance, which typically means that the individual won't even be approved until they clear the applicable program. Visas Merlin is the background check process for all refugees and asylees. It's been in the news a lot lately. I'm not going to go into it at length, but basically it's an extremely thorough program that, in my experience, and I hate saying this or agreeing with some of the negative media out there, does make mistakes and does let people through who have minor fraud issues. I've never seen a major fraud issue myself, although there have been reports of it and congressional hearings on it. Most of the minor issues that happen is when the UNHCR asks someone, hey, how old are you? Well, I'm 18 years old. Oh, that means you must have been born in 1999. We're going to put you down as born January 1st, 1999. And most people actually know their date of birth. There's only, in populations that don't keep track of it, it's less than a quarter of them usually don't know what it is. But that's just the reality of it. I try to fix those cases after they're here by having them do a 602 waiver with their adjustment of status. But that's beyond this talk. Visas VIPRE is a fun one. It's actually a reporting program. So they don't do a clearance check for it. Oh, give me 1 second. There we go. They don't. Can everyone still hear me? My mic got interrupted for a second. Okay, good. Visas VIPRE is a program that is used for reporting people that the embassies and consulates believe may be known or suspected terrorists for inclusion in the relevant terrorist watch list, which are then called under the various visas programs and are managed by the FBI. Not all posts. Here's the trick to these things. Not all posts retain the information on why they decided to nominate an individual to the terrorist watch lists, which can be the basis for future false hits that are exceedingly difficult and sometimes impossible to remove. A rather ludicrous example is last year I had a client who I did discover through talking with the various government intelligence services that were willing to talk with me about my client. He had matched a watch list as a known terrorist, which is a little bit scary to be told that your client is a known terrorist. I said, tell me what known terrorist he is, and they didn't want to give me that information. So I spent my time digging into the client's history, his name, and everything else. The best match I was able to get is that the name of the political party he'd been a member of in his home country and his own name matched the name of a known terrorist who lived on another continent in another country, who was a member of a terrorist organization that unfortunately has the same exact name as the political party my client was a member of. It took me a ludicrous amount of time to get through to the government's head that these were two different groups from two different countries, because apparently their database didn't carry that. Additionally, the individuals had nearly the same birth dates. I ultimately managed to dig up a picture of the actual suspected terrorist from old footage in the 80s. Quick hint, he was Irish. My client was Central African. They definitely don't look alike. I asked him to do a facial check. I reached out to the OBIM and did a FOIA check with them, and lo and behold, they weren't the same person, at which point I used a rather interesting remedy, which is to do a privacy Act amendment request, which is discretionary for foreign nationals. The government doesn't have to grant it. They did. They amended the records and added to it that the original person on the terrorist watch list was white. And that suddenly cleared my client up because the officer, we scheduled another interview. He goes in and the officer's like, oh, yeah, you're not that person.
Would you read David's question out loud and then answer it as best you can?
Yeah, David Jacobus, you found that applicants with intelligence backgrounds often had their travel history examined, resulting in administrative processing, but the consulate never disclosed the category of inquiry. Any idea which it was? Depends on the country, but the program that most of those people are going to be falling under is one of the I'm not going to actually give you a direct, easy name because they mix these programs up internally when they do the checks. But oftentimes people who have former intelligence backgrounds worked as government officials. And so they'll pop up either on one of the government officials' checks. Sometimes a lot of times they'll actually pop up under visas Mantas because their knowledge in intelligence is likely related to surveillance, which is one of these sensitive and critical fields of information. And so the government will be concerned about some type of counterintelligence operations or sharing of U.S. surveillance methods with foreign countries. Going back to visas VIPRE, let's see where I was. Visas VIPRE's individuals are ultimately screened and put on the terrorist screening database. That database keeps getting bigger, not smaller. That it is maintained by the Terrorist Screening Center at the FBI. The TSC list, Terrorist Screening Center list, is generally separated into two groups. It's kind of how you figure out if your client's on these. One is the no-fly list, which means your client probably already has access to the U.S. or tries to fly over the U.S., which completely blocks visa issuance, as well as any commercial aviation travel through U.S. airspace. I have a Canadian national who is on the no-fly list. Must show his frustration. And on the full exclusion no-fly list. So that means if he wants to leave Canada to somewhere else, he has to go over the pole. In fact, he has to drive north before they will let him onto a plane because he lives too close to the border. One of these days, he'll actually let me sue on his behalf. In the meantime, it just keeps sitting there. The selectee list is the other list, which requires additional screening, and you'll see it when someone's flying to and from the U.S., and they get every single time that nice little stamp on their ticket that says SSSS, Secondary Security Screening Selection. If you're not on the selectee list, you might be one of the random people given that. Random people tend to get a nice little tummy rub from TSA. Selectees tend to get a private tummy rub. Exciting, especially as someone who has had that tummy rub at least a couple times himself. Thank you, anyone that's listening to me from the government. Massages are always great. So, Visas Condor is additional screening and background checks based on country of birth, citizenship, or residency. And this typically these are people who are in the T7 list. That's the state sponsors of terrorism: Cuba, Iran, Iraq, Libya, North Korea, Sudan, Syria. Or they're from the list of 26. I'm going to read this off really quick. You can already guess what this is. Oh yeah. Well, there. Hey, you can read it yourselves. So. I forgot I actually put it on the slide. It's a mandatory stop list, and supposedly it takes only 2 to 4 days to process someone through it. That's actually true for women from those countries in about 90% of cases. However, and a lot of that's thanks to the rollout of Patriot, which is a system managed by ICE. It's the Pre-Adjudicated Threat Recognition and Intelligence Operations Team. They love that acronym. They use it for everything. It gets really confusing. The problem is that they have some severe issues with Patriot, including the fact that it, according to OIG, has no metrics for measuring the success of its programs or its failure of its program. And so they don't actually know if it works. That's always a fun thing to find out about your government when they don't know if something they're doing works or not. That's the same for the VPUs and the VPS programs, the visa protection systems. They actually don't know. They get harassed every couple of years by OIG in Congress saying you need to store metrics on this. They don't. They always have an excuse not to. The Patriot systems managed by ICE, it often takes, especially for mails from these countries, 3 to 6 weeks. And if there actually is a hit, they're going to pop over to Visa's Donkey. And we don't know how long that takes sometimes. Visa's Donkey, this is the one that holds up almost anyone. If you've seen them there for a long time, it means they might have had a hit or an ident match. Those come from NameCheck. There's other programs that they can come from as well, and otherwise of ways of getting a biographic match. A hit is a near match, of which allegedly 98% are resolved in 120 days. Basically, a near match is that the name sounds similar or spelled similar, and the date of birth is within a reasonable margin of error for the individual. Ideally, it's within a year. I have seen someone have a hit on the record when the date of birth was about 15 years different. That said, there was reasonable cause for it since my client's date of birth was January 1st. I don't know if anyone's ever had to deal with a lot of refugees, especially Somalis, but I am convinced that Somali National Conception Day is March 27th. I do send out Valentine's cards to my Somali clients once in a while, at least the ones with a sense of humor. The ident is literally identical hit. The government might tell you it's a different acronym. It probably is, but that's the only definition that ever made sense to me. It's an exact match, typically resolves in about 30 days. Some of your more complicated hits literally will require the government to identify the person that they think you are as physically being in a separate place from you at the same time. That can take a long time to do, depending on where they're from and where you're from. So, Visas, Condor, Donkey, VIPRE, and Mantas are all suffering from near exponential growth due to the increasing size of the relevant databases. Basically, we throw people on to terrorist watch lists, criminal watch lists, and all types of names on them, including people that are bad counterintelligence. Afghanistan, Ethiopia, a couple other countries are really bad at doing this. They report people that are political opponents as terrorists into international systems. U.S. takes that seriously, and they're like, oh, no, don't let them come here. Kazakhstan does it once in a while for parties that they don't approve of. It happens quite a bit worldwide. It actually happens a lot in South America as well. Venezuela does it fairly often. The government takes all of these seriously, though, so that's about it. And someone noted that my list of 26 countries has only 25 in it. They're correct. I literally don't know why they list Dubai and UAE as two separate countries, but they do on that list. So I don't know what to tell you about that. There might be another country out there somewhere, but that's the best list I've ever been able to pull up on it. And I might have deleted Dubai from it when I was doing it because it's like, how's that different from the UAE? Let's see. So the SEAOs are increasingly backlogged because we have ever-increasing numbers of visa applicants. We also have a lack of resources, especially when the government's trying to defund the Department of State and everything else. And the databases keep getting bigger. The result is that these programs are guaranteed to continue to get slower, exponentially slower, unless dramatic improvements are made to interagency cooperation. For example, Department of Homeland Security and Department of State don't always get along. That can suck for you. You can also use it to your advantage. More resources, more coordination, and better intelligence data screening. Quite frankly, the government at some point is going to have to start actively removing people from these lists because a lot of them just have bad data in them. We've all seen the news reports of a 1-year-old who matches a terrorist name and gets held up at the airport for 2 days. Not a fun thing. Exacerbating all these delays are the new policies from Department of State and Department of Homeland Security. which they're trying to promulgate in response to President Trump's proposed travel bans and his various other executive orders. For example, Secretary Tillerson sent out several cables in an attempt to enact the second travel ban recently. Luckily, that's on is it injunction or a restraining order at the moment?
Should be TRO.
Yeah, TRO'd at this point. These cables included many provisions. You literally can search for my last name, and thank you for everyone who said that's a TRO. You can literally search for my last name and an article on Reuters to actually get copies of these. I don't mean that as a plug of myself, but it's the quickest way to reference people to them. These cables include many provisions, a lot of which aren't rescinded. They really are worth a careful look. Along with executive orders, there's only a handful of areas in those that are actually been TRO'd. Among those that were rescinded, though, was the inclusion of all nationals and residents and people who have visited Syria, Iraq, Iran, Somalia, Libya, Yemen, Sudan, so the countries that we expect. And yes, Iraq was on that list for additional security, scrutiny, and background checks under Visa's donkey. So basically, even if there isn't a hit or an ident check, they are required to go ahead and run those people through Visa's donkey in order to check it. Now that's stopped under the TRO, but Visa's donkey is already backlogged. So as shown in the recent cables, in the event that Trump does manage to get his executive orders through regarding the travel ban, or the U.S. does what they could do, which is basically pass them through as internal processes and not crow to the public about them, we can virtually guarantee that the Visa's donkey program will grind to a halt, trying to handle the additional burden of individuals receiving additional scrutiny. By adding these people, it would instantaneously increase the volume of cases processed under Visa donkey by approximately 25% per year. That's based on the number of visas processed per country in 2016 and the existing statistics on how many cases are already processed in this category. The existing statistics are around 2 to 3%. It's going to add, another 0.5 to 1% of cases for review. That's a lot of addition for something that's already a stressed program. The simultaneous reduction in funding for visa processing and the reduction in the number of daily processed visas, which is a good thing. Hey, we're down to I think it's 120 visas per day they're supposed to be doing now per officer in interviews, which is, I don't know, sounds ridiculous. And depending on how you do your math and how many hours you think they have in a day and how much breaks they get, somewhere between 3 and 5 minutes per individual, will dramatically increase the time it takes to process all these cases impacted by the various ASAO processes worldwide, especially those impacted by Visa's donkey and Condor. And I'm just going to be honest, unless you actually have a lot of in-depth information that points at one of the other programs for holding a client, you can pretty much guarantee they're held under Visa's donkey, Visa's Condor. You got to look at the country and nationality and the other issues to find out what other program they're held potentially under, though, because it does affect a little bit how you strategize. You need to be creative. The other thing is that there are barely 26 visa security program units worldwide. They might be up to 27 now that handle much of this review and the training consular officers for it. These delays are just going to get longer. They're not going away. The visa security units, I'm going to actually read these off because I find that these are the posts that people recognize as having problems with and lots of delays. Riyadh, Jeddah, Manila, Abu Dhabi, Dubai, Islamabad, Caracas, Venezuela, Montreal, Canada, of all places, Hong Kong, Casablanca, Cairo, and Nairobi. Part of the problem with extending that program is that that's a joint DHS and DOS program. DOS doesn't like giving enough room at its embassies to DHS to station its officers. So, for example, Nairobi, which we find often has a backlog, has the smallest VPU unit, but has one of the largest case logs for the types of cases it does in its region. Top it all off with FDNS-style fraud detection, FPU programs, and then you layer on top of that consular non-reviewability. In the more complicated cases, we have a fairly straightforward recipe for hurried decisions rather than adequate scrutiny. And at the same time, if there is adequate scrutiny, it takes years. So it's like a choice of which way do you want to go. Finally, according to a variety of OIG reports, most of the historic administrative processing delays have been actually caused by errors in visa submission by the petitioner, sometimes by the post. For example, I have a case I'm pretty much guaranteed it's going to go to administrative processing because they insist on spelling my client's name wrong, even though every document he has it the same way. And every time I see it, I'm like, no, you've got it wrong. And they have now told my client at his interview yesterday, we're right, you're wrong, you don't know how to spell your name. Yay. So the other thing is false hits with one of the many watch lists, and increasing number of visas requests, and then there's actual hits with the relevant databases. The unintended result of all of these is even more frustrating, and people who deal with a lot of admin processing have probably seen this happen. Consular officers are encouraged to increase the scrutiny on cases potentially impacted by lengthy administrative processing in order to come up with a basis for pretextual denial. Same thing we see in our carpentry cases at Homeland Security. Wow, that's a hypo posted over there. Basically, pretextual denial is, we don't want to do all of the work necessary to vet you. Let's try to find a little reason to deny you that you can hang on it. You see this a lot in family cases where you're told they're not really married. You're like, but they have 4 kids. Yeah, we don't think they're really married. Or you'll see it where they say, oh, we don't think the U.S. company really is operating. We want to send it back to Homeland Security for additional processing there. Those are great. DHS holds it up for years. Nobody will actually tell you where it's at. You can actually, here's a tip. You can find out where your case is by asking for the diplomatic pouch number that your case is being transferred in. They're supposed to tell you. You can't track it yourself that way, but they will tell you, and then you can call the other end and say, hey, have you received this package number? The only exception to all this is when DHS itself wants to carry out additional carpentry review on cases, because in my opinion, it is intentionally doing that work behind the shield of consular non-reviewability. You actually read their CARP policies, and it says, hey, if you identify a CARP issue on a petition, don't adjudicate it. Just mark the file with a warning. Send it to DOS. DOS will actually do a check to DHS for the background checks later on, and then we'll deal with it. At which point, it tells the post to hold up the case, and you get to sit around and wait to see what's going on. Now, the part that everybody really wants to actually hear from me: how do you avoid all of this? You don't. You can't. Administrative processing is simply going to happen. So that's the end of the presentation. No. Sorry. You can't avoid administrative processing. It's literally baked into the procedures for it. But what you can do instead of avoiding it is you can reduce its time impact. In order to do that, you need to be semi-familiar with the various programs that I just discussed, thoroughly familiar with your client's case, and ready to preload information into the case that is necessary to basically make the checks easier on the government and get the case past DOS. Quick practice tip here is that by preloading as well, DOS can't say no to a decision made by DHS if DHS had the evidence on record that supported the conclusion. They can't reach another factual conclusion without showing some actual facts to the contrary. So, and it can't just be simply a bad interpretation. They actually have to have real evidence that can throw a case. Preloading can throw a case into administrative processing for fraud checks, but most of the time it works out in your favor. So what is preloading? Basically, it is submitting documents early in the case and often. These are documents that preempt or reduce the variables that need investigation before visa issuance. With an immigrant visa, that means you need to submit at USCIS. You need documents that you otherwise wouldn't think of submitting. Don't follow just the simple list of the documents required. You need to update it with the National Visa Center. You need to update again with the consulate. For non-immigrant visas, it's a little bit more complicated. You notify the consulate directly if it's a complicated case. Hopefully you have a good relationship with the NIB unit at that post, and you prep the client with a strong elevator pitch. I tell my clients less than 45 seconds they have to be able to explain to the officer why the officer wants to read those supplemental briefs and documents. So what exactly is preloading? Well, preloading is straightforward. It's basically being prepared for what's going to come in the case. I'm going to warn you, clients will try to fight you on doing it. They'll say, well, nobody else requires these documents to be submitted.
So Jay, what might be on that list
of
preloaded documents?
Gonna get to it. I will get to the list of things to put on it. It's going to sound a little bit vague because it depends on what's the problem with your client and which program you think they're going to fall under. I could literally spend all day giving you hypotheticals about how to preload cases. I'm going to instead talk a little bit more generally, hopefully give you the tool set so that you can figure these out yourself. You're always welcome to email me, and if I have time, I think Greg can speak to how fast I respond to emails sometimes. I'll try to answer your questions. In fact, I recognize a few names on this list of people I've talked to in the past. So let's see, where exactly was I on this? For petition-based visa, it's in your client's interest to preload information commonly used to deny cases for that type of clients. For example, marriage visas, you want to go ahead and actually preload additional information on the marriage, even though it's not required to do that with DHS. I mean, with a marriage petition, you technically can just simply give them a copy of the marriage license and show there's a legal relationship. You need to actually be proving bona fides up front with DHS. You need to follow this information at petition time with DHS, even if it's not requested in the instructions. For example, when dealing with high identity fraud countries, Somalia, Yemen, lots of other places, it's a best practice. And if you ever want to get a good list of these things, I'm not advising you to go read cable gates and search for fraud cables, but they're really useful and interesting. It's a best practice to include, in high fraud countries, it's a best practice to include multiple forms of documentation establishing the individual's identity beforehand. And I do apologize for going a little bit long here. While it may only be necessary to include a passport, or in some cases where a passport may be waived, it's far more efficient to make sure you include other forms of identity from the beginning. That means UNHCR identification if your client is or has been a refugee and is displaced. This is really important for your Syrian family members, Syrian employment visas, Somalis, Yemenis. Any country that has an active conflict, you want to make sure you provide adequate information on identification, because the foreign government is not always going to be there to vet against that. Country identification records, if they have them, old cards, school records, other documents that thoroughly establish the individual's continuity of identity, because that's the real issue, is that that person has used their identity for more than 5 years. Secretary Tillerson's cables hint that that's probably going to be extended to 15 years. Good luck proving that a Somali has had the same identity for 15 years when they've had a war that's basically made their government incapable of adequately proving identity for 25 years now. Hopefully they were born in another country. By providing this additional information to DHS, you allow the security screening to start sooner while it's with DHS, and you can directly protect your client from a denial at the consulate based on an allegation that your client did not adequately provide that information or something else that they wish to do for a pretextual denial. You also make it a lot easier on yourself in the event that you ever have to actually litigate the case, because you can say, hey, this was on the record with DHS before. We provided adequate documentation. We provided it again to DOS. We don't know why DOS reached the conclusion my client didn't provide adequate information on their identity, because it's in the record. For immigrant visa cases, you may also want to update these cases when you get to the AVC, again, at the consular stage. In fact, I absolutely recommend it. I send those documents in multiple times, and if there's anything new my clients managed to come up with, I add it to it. As a result, you'll optimize the possibility that the consular officer will actually receive and have reviewed the relevant information, that a supervisor will actually get it, because consular officers are really bad. I don't want to take any papers from you. Only give me things I tell you to do. Only talk when I ask you a question. Only answer my questions. And sometimes I won't let your client get that elevator pitch out. Or that the relevant information is readily available to whatever agency will be doing the necessary investigations and will make a final decision for your client, or so you have it on the record when you get to litigation. For your non-immigrant visa petitions, same thing, but include it in the application. When a client has experienced multiple denials already, I actually go so far as to send the information to the embassy ahead of time. These embassies give themselves usually about 30 seconds per email. 30 seconds to read it, 30 seconds to write a response. Big, bold letters at the top, what you're requesting and what the importance of actually reading the email is going to be is just a major thing you need to do, and making sure you stay up so that when they respond to that email or you have them on alert so it pings by your bedside, especially if we're working with embassies on the other side, so you can respond to them immediately is great, because embassies will actually get into conversations if you respond to them immediately, as opposed to making you wait for another 2 weeks till you reach the top of the queue again. I do encourage my clients to never let an officer refuse to take documents in these cases in order to avoid administrative processing. Plenty of officers do. I have more than once said to the client, leave the copy of documents on the counter when you walk out. They don't always appreciate that. I've had security track down a client and hand them forcibly the documents, and the client just says, thank you very much. I must have forgot it. Don't lie, just, I must have left it on accident or whatever. Yes, consular officers do have a limited time, but there's nothing more frustrating than have a client explain to you that, oh, I was denied because they said I didn't bring any evidence of talking with the company that hired me, and why didn't you provide that to me? And you're like, it was in the evidentiary packet. It was tab A. Why didn't you show it to them? Well, I tried to show it to them, but they said they wouldn't look at it. It's like, this is why you got to preload things, because then it's already in the record. Note, there are exceptions to preloading cases, but they all come down to a certain amount of common sense here. If you think evidence will lead to an unfavorable misinterpretation of your client's case, then you probably don't want to submit it unless it is required. If it is required, you better be explaining it, and don't lie for your clients, because all these cases are based on your reputation. You get caught lying for a client, you're screwed. Your reputation is toast with the embassies, and you're never going to get them out of admin processing. In fact, they'll start putting cases in admin processing because of the attorney of record. I've been through that through personal experience in 2012 through 2013. Every case I filed in those years that went to visa units through admin processing for additional checks. I ultimately was actually told by a consular official that that's why, because I was dealing with so many of these crazy cases, and so they were wondering, why did I do them all? The ultimate question that got me off the hook was ridiculous. I sat down with a couple of agents from certain agencies in my office who kindly asked me, so I said, I think that everyone has a right to due process, at which point they said, oh, but aren't you a Muslim yourself? Oh, all right. What's extreme vetting? I know I'm way over time here. Sorry, folks. Extreme vetting is not hopefully in place. If you read through Secretary Tillerson's recent cables, there's some ideas of what are going to be asked for extreme vetting. And this is a great example of preemption, because this will help you preempt future visa donkey reviews by preloading your applicant's additional information that will be requested. My gut instinct is to fight the government on this and say, you don't need it, this is ridiculous. But here's the information that they're asking for: 15 years of travel history, names of siblings, children, and former spouses, 15 years of addresses, all passport numbers. Good luck remembering those. 15 years of prior occupations and employers, along with a detailed description of the job, work, and the people you work for. 5 years of phone numbers, 5 years of email addresses and social media handles. I'm going to be honest, I can't remember every social media website I've signed up for. And sometimes my pre-done handle isn't available. So I will be honest, I would not be shocked if this program is eventually labeled visas porcine, or simply features a slice of bacon that has to be ate in order to identify whether or not someone's a security risk. I realize that may be insulting to some people, but that's the way it feels. Now, I can spend a lot of time talking here about privacy, what privacy rights aliens might have, and my opinion of these suggested items or requested information that thankfully are on hold at the moment. But ultimately, my job here is, and our job as attorneys, is to unite our clients with their families or their employers in the United States as quickly as possible. Thus, unless my client and the petitioner really want to fight it and risk years of additional time and potentially being outright rejected or accused of fraud, it's going to be far easier to play along. I give it the option to my clients. I do tend to encourage them, like, hey, let's fight it, but here's the risks. And most of them say, let's not fight it. Except note that I got to note here that I'm not a serious fan of providing email addresses and social media handles. There is just too high of a probability that an individual can lose control of their social media account. They get hacked all the time. When the government starts asking me for those, I'm going to start telling the government, hey, how many of your handles have been hacked this year? And quite frankly, people say stupid things or take stupid pictures that are easily misunderstood without additional context. One of my favorites of a case I had that actually did get pulled because Visa's Donkey revealed their social media. My client was put on hold with Visa's Donkey for over a year. Ultimately, I got the petitioner and the FBI in my office to figure out what was going on. They were completely hung up on one post. They wanted to know what my client's wife had meant by writing on her Facebook post publicly, I'm going to go visit ISIS this summer. ISIS was her newly born niece. So it took a little bit of explaining that, showing the pictures, showing the links to it. So what happens if you're already stuck? And yes, I was joking about Visa's bacon. I hope nobody was offended by that. Well, vaguely. So what do you do if you're actually stuck already? Because that's usually when we get these cases. My favorite love is the notarios who go, oh, I screwed this up. I better send it to an attorney. It's exceedingly frustrating, and I hope to put all those people out of business eventually. So sometimes, no matter how much you preload, or because the case didn't start with you, or because you're just finding this information out now and you haven't been preloading, a case will simply just get stuck. It can also get stuck because for a variety of reasons. You may know what they should be ahead of time, you may not. In these cases, you need to slowly work through your remedies until the case is processed or is ripe for litigation. I know I've been asked for an hour now, why is my case stuck? Which program is it stuck under? How do I figure it out? I really wish I could just give you a blanket, oh yeah, your case obviously is stuck under this program. It's not that easy. You need to identify why your client's case is stuck. So to do that, you need to sit down, review the case very carefully. Quite frankly, if you don't know how to interrogate someone, especially doing what's called a passive interrogation, where they don't feel like they're being interrogated, but you're soliciting answers from them that they might not otherwise give you, you need to learn how to do it. There are plenty of books on it. The books suck, but figure it out. You can also, if you do enough interviews at USCIS, especially FDNS interviews, figure out how they interrogate people and take tips from that. I've learned a lot of my interrogation techniques from watching how the FBI handles conversations with my clients. I've talked to some people who have historically been intelligence officers. You need to figure it out. You need to be able to interrogate your clients. So interrogate them. You need to dig from their brains, and they'll have forgotten already because of all the stress. Just going to the interview. What did they say at the interview? What were they asked at the interview? What documents were taken? What documents were looked at? What documents were refused? And then you need to look over their actual case history. Was there a mistake on spelling of the name? I don't know how many times. I literally cannot tell you how many times because it's too many to count. I have had cases where I'm pretty much convinced that admin processing happened because The petitioner wrote the mother of the applicant's name one way in the petition. Somebody wrote it a different way in what was the G325A. I guess it's going to be I-130A now. Another person wrote it differently on the DS-260, and then the client at the interview wrote it another way. And then you go and look at all the documents, and it's written in a half dozen other ways, or the individual's name is spelled differently. You got to reconcile these things from the beginning, or if it hasn't been reconciled from the beginning, you need to make sure when you reach out, say, hey, are you getting a lot of excess name hits here, which means you're probably going to get extra scrutiny for aliases under Visa's donkey. Let's figure out what my client's real name here is and go back to identifying them correctly. Not all names anglicize well. Was there, also figure out, was there information accidentally omitted earlier or intentionally omitted? Is the client from a Visa's Condor country? Does the client have experience in Visa in a technology area that's relevant to Visa's Mantas? Has the client previously applied for visas or been in a place that would have got them elected through Visa's VIPRE? Are there other people with similar names that would potentially have them been elected under Visa's VIPRE that'll hit the person? Does this person have a common KST or EPS name? These are acronyms you need to know. KST is known or suspected terrorists. It is under the CARP and TRIG programs. CARP is authorized technically under TRIG to terrorism-related inadmissibility grounds. By the way, there are also non-KSTs on the watch list. Non-KST is someone that's suspected of potentially being a KST, but isn't a KST, or is maybe associated with a KST. It's really confusing. If you're not actually on that, you're actually an NNS, non-national security concern. EPS, egregious public safety. You're going to see that a lot more in Latin America, dealing with cartels, people who have drug issues, former criminal issues, gang issues, South America, that type of stuff. You do see it once in a while for Russians and as well as East Asians, especially if they've been playing along with whatever the favorite version of mafia, mob, or whatever organized crime it is in that country, or know people who have been or just live in the wrong areas for it. You need to figure out what's going on to the best of your ability, but you can't drive yourself nuts on this because sometimes you're just never going to figure it out, which is why you have strategies that are both generic and things you can do specifically. Other ways to figure out why it's actually stuck, reach out to the consular post and ask them what's happening. They're going to give you a generic statement about administrative processing. Once in a while, you get someone nice who adds a couple extra words. If you notice the various forms for telling you about admin processing sometimes will say it different ways when they email you a response or call you with a response. That can give you a hint, if you pay attention to the patterns from that specific post, on which program it may be under. Sometimes you'll even get a direct answer, oh, it's a legal advisory opinion, or oh, we have questions that we've submitted back to DHS. I find a lot of times they'll tell me if it's being handled at the post or if it's handled back in DC, but not always. If you know why it's delayed and believe you can remedy it, you need to escalate this to a supervisor and actually give them an explanation for the issue. Big tip here, don't add new facts unless necessary, and do your best to never contradict anything else on the record, because I have clients who are held with these programs because one attorney worked on it before me, or notario started, messed up a few ways. An attorney before me tried to explain it. An attorney before that tried to explain it. An attorney before that tried to explain it. And while the government's not supposed to use attorney memos as evidence, they sure like to. So whenever you have a client write a declaration, you need to be careful here. Don't contradict the record unless you have a good explanation for why you're contradicting it and how you're going to fix it. If you don't have any good information, you're going to have to wait that 60 days for admin processing to work on it. A lot of cases do resolve in that time, and then you need to do an inquiry again and ultimately escalate to a supervisor. Sound is starting to cut out. Okay. All right. Not on our end. You can reach out to ALA's committee liaison. I've had them actually be really useful on a couple cases where it was a very general issue. On the other hand, and I mean no offense to the DOS liaisons at ALA, you guys do a hard job, but like when the MNEs were having huge problems with SANA, they kind of threw up their hands and said, we don't know what to do. We talked to, you have to prove that it's an issue. It's like, okay, well, I've got 50 attorneys here who are all having the issue. Oh, that's interesting. When they have tried to go to DOS over the additional name scrutiny for Somalis, they get told it's a national security program. They're like, oh, good luck. It's like, thanks, guys. Thanks for the help there. But they do some great work in other areas. You just got to pick it carefully and keep pushing on them. If you can gather case examples from a bunch of attorneys, if you see other attorneys encountering the same program, pull them together, send them into the liaison all together separately and say, help, help, help. It'll get their attention. For non-immigrant visa cases, you can always reach out to the department's visa office directly. Sometimes they'll talk to you about it. I talk to the various desk officers as well about the programs for country desk officers. You can look up the country desks for every country. Talk to the desk officer, talk and ask them, hey, what do I need to know here? What's going on? They won't usually talk about a specific case, but they will give you more information. And sometimes they'll take information to pass on to the embassy about the case. I've also found it useful to talk to American Citizen Services when the petitioner is a citizen. You can reach out to the MVC. I find it useful to find out if it was actually sent back and isn't really in administrative processing. I've had cases where I found out they've been sent back over a year ago. I've also had cases where they told me they sent it back and they didn't. Those are usually cases that had a hit with one of the terrorist watch lists. You can follow congressional inquiries. Make sure you know your Congress people. Some of them are amazing to work with. Some of them are useless to work with. It really depends. You got to make sure you know them. And you need to help them understand the case and what they can actually do to help. A lot of them will just send an email to the embassy. Sometimes they'll get better information. A lot of times they don't. If it's been over a year, encourage them to reach out to DC instead or to a DOS headquarters and ask there. If I know a program's held up with the FBI or something, or at least have a good suspicion of it, I'll ask them to reach out to Homeland Security or the DOJ instead. Some of the congressional offices will be like, why do you want to do that? This is a problem at DOS. And I'm like, no, this is a security and background check. Please reach out to the agencies that process that so that we can figure out what's actually going on here, or at least nudge them to start working on the case. I use that deal of whether if a case has been pending over a year quite regularly. I say, hey, can you reach out to HQ? HQ will actually copy and paste information from the cables sometimes to a congressional liaison. Some of those liaisons are really nice to actually pass those on. I am not going to name names because I understand it is a violation of ethics rules. At least that's what I was told at one point. So we're wrapping it up. We're almost done. Finally, you can litigate under mandamus. I'm going to be honest. You can litigate delays. You probably will get denied on the case, but I like getting denials because most denials, especially with immigrant visas, are recommendations for revocation. What does that mean? It's coming back to Homeland Security. What can you do when Homeland Security takes too long? You can sue them and not worry about consular non-reviewability. DOS absolutely has a duty of due process to make a decision. They can't hold it indefinitely. You're going to run into problems with consular non-reviewability. Quite frankly, that thing's going to die eventually, but we're working on it. I've already talked about a lot of these miscellaneous tips. Just a couple things. Don't get angry with DOS. They, a lot of times, are stuck because of other agencies, not themselves. Do use humor. When you use humor, use it cautiously. Don't go overboard with your humor unless you really want to trigger a visit from diplomatic security. Don't get angry. They can interpret that as threats, and you might get a visit from diplomatic security. I've had clients have that happen. Reach out to other agencies. FOIA the other agencies. I FOIA Homeland Security and FBI and the various other agencies all the time for my DOS cases. They're a lot faster at responding. You can FOIA DOS. There are some weird little exceptions to it. When Bob Pau's next book on litigation comes out, he actually has some really good information in there where you can. There's cases that say that if it's a revocation, not a denial, you can actually get a copy of the record. There's been a few cases won on that in lower courts. be understanding and informative, be creative, and remember, hey, if you can respond immediately to them, do it quick. The embassies will continue communicating with you. Finally, client management. I'm going to just break this down real quick. Be upfront with your clients. Beginning of the case, say, hey, you might get delayed because of your nationality. You might be subject to one of these programs. It might take an extra year. I'm just going to warn you on this. We're going to do everything we can to prevent these delays. You will have clients who will say, well, we don't have to submit all these extra documents for preloading it because nobody else requires it. My friend's case went through just fine 14 years ago. And you're going to say, that's nice. Go look at the news on immigration. We live in a different world now. It's going to be better for you to do this ahead of time. I haven't had preloading really come back and bite me yet. But you just got to, doing it helps. Be understanding, listen to your clients, listen to their frustration. If you don't have the time for it, find someone in your office who does. It's very frustrating. Echo it back to them and just, say, look, I understand you're frustrated. But the best thing you can do here is we all get those clients that range from like you never hear from. Those are great. To the clients who want to literally knock on your door at 6 p.m. every day and demand to know what the status of the case is. And you're like, it's going to take 6 more months. Give me a break. Informed clients are happier clients. Give them a letter. Have your secretary at the front desk always have a letter there for that client. If they come in every day, say, still waiting. Wait 45 more days. Always be honest with your clients. And that can mean simply saying, I don't know what's going on. I'll try to figure it out. We may never understand it either. But we will get this fixed one way or the other. I'm frustrated with this as well. Clients actually like to hear you're frustrated. And hey, you got to be patient here sometimes. A lot of clients in these positions don't want to sue because they don't want to take the risk of denial. At the end of the day, that may be their only option. And you got to work together. I love it when I have clients who are proactive and just reach out and keep calling the embassy, keep emailing the embassy. As long as you keep them on message and not saying too much and not being angry and not threatening. A lot of times the office will be like, okay, squeaky wheel gets the grease. So at the end of the day, though, with all this, you got to remember, relax, try to step away from it, step away from the office sometimes because these cases can be extremely frustrating. Any other questions that I missed or anything else?
We have a few if you want to scroll back up.
Yeah, and I'm sorry for going over here, folks, but it's a lot of information. Yeah, Steve here asked, can we post load to add material to pending but undecided petition? Yes, you can. A few posts have taken an interesting position that it is an intentional act of misrepresentation or fraud if you submit documents that are not requested or not solicited. I think they have no basis for that, but there's your warning on it. Let's see. Speaking of clients who pound at my door every day at 1:30. Let's see. Erica asked a very long hypo in the sidebar here.
Could you repeat the hypo?
Okay, so I'll go ahead and repeat the whole thing. Erica has a hypothetical about a case where a daughter and grandson of a United States citizen were interviewed in Ankara. They're Iranian citizens. 3 days before the first executive order went through, they were told after the interview that they were approved and their passports were taken for visa stamping. After the executive order, passports were returned. Passports were then accepted again after the first TRO. After saying everything was processing fine, including it'll just be a few more days before the passports are ready, the consulate all of a sudden got back to them to say that the family is now in admin processing. Out of nowhere, after all they've been told multiple times they're approved, they believe it is clearly pretextual hold while they figure out how to keep Iranians from coming here despite executive order being on pause. Senator and Congress people have done inquiries for them. They email constantly. They run out of options. What do you do? I have far too many cases where they've been put on hold lately, interviews that were canceled and haven't been rescheduled. This is frustrating. tip on my cases where the interview was canceled and not rescheduled, I tell my clients to show up for the time of that interview that was originally scheduled for. Every single one of them has been accepted for the interview, even though the embassy never notified us that it had been reinstated for the interview. Most of them have been told they're approved. Visas haven't been issued yet. Visa issuance is actually handled back in the US. It is possible that it is intentionally being held up. We're only going to be able to prove that through a pattern and practice unless somebody out there manages to get a copy of a cable or some document saying that it should be done. Good luck getting that. DOS is notoriously stingy about sharing information. How do you handle it? Well, if you're lucky enough to be in a state with a active attorney general litigating this stuff, you need to reach out to that AG and provide your case as a sample case. That'll escalate it. I actually have a case where we just did that when the ACLU was updating one of its pieces of litigation. We submitted it anonymously, but we provided the dates and times of the interview and everything. And mysteriously, 3 days after the amended pleadings were filed, my clients got their visas. So it is worth doing that. The other thing is start looking up the Foreign Service Officer names, put together what their email addresses are likely to be. Key Foreign Service Officers, Google it. There's a list of them. You can use their names to generate what their individual email addresses are. They probably won't reply to you. It will bounce if they're not a real address most of the time. Some people, if they're second, third generation, there'll be multiple names and you might get the wrong person. But email them along with the post. Make it clear that you're emailing both of them. Ask for supervisory review. Cite the sections out of Secretary Tillerson's cables saying that all visas should continue to be processed and approved and interviewed during the time of the temporary restraining orders. If they continue to fail to do so, you need to actually consider litigating yourself or joining litigation to force them to go forward with the TROs. As you may be aware, there's a few states where that hasn't. The TROs haven't been enforced. There's a question on what would happen if you tried to litigate in those states. And there's always the question in these cases of standing. So that's about it. Were there any other questions? Oh, that works too. There. That part talks.
Okay. We're going to have to call it a wrap at that. Thank you very much to Jay for the extreme preparation, so to speak.
Sorry for taking so long, but hope it's helpful.
Folks, this material, so we'll include the slides, the video, and then a blog post with Jay's material will be up in about 24 hours following this event. I'll shoot out an email when it's available, but it'll be on soundimmigration.com under Stuff for Lawyers. If you guys have any ideas for a presentation that would be similarly helpful, please feel free to shoot me an email. We're always looking for good ideas. I think actually this was one of the most timely and helpful ones that we've covered so far. So big thank you to Jay for doing this. You guys can't see it, but Jay hooked me up with a Make Lawyers Great Again hat, which is perhaps the coolest thing I've ever been given at any law function. I'll include that on the blog post. Thanks, everybody. Do awesome work out there. Get past the administrative processing hurdle, and we'll see you next time. Take care.